Meanwhile, across the street at the Supreme Court, justices are considering whether to weaken a key provision of the Voting Rights Act. They heard arguments earlier today in a Louisiana redistricting case over maps that the state was required to redraw to ensure that there were 2 majority black districts. The case specifically focuses on Section 2 of the law, which prohibits voting practices that discriminate on the basis of race. The court's conservative majority seemed open to barring the use of race in redistricting. The 3 liberal justices, however, arguing that race has been used in this process for years.
The issue, as you know, is that this court's cases in a variety of contexts have said that race-based remedies are permissible for a period of time, sometimes for a long period of time, decades in some cases, but that they should not be indefinite and should have an endpoint.
Race is a part of redistricting always. We've said that the only actionable part that's intentional if it predominates. But race is always a part of these decisions, and my colleagues are trying to tease it out in this intellectual way that doesn't deal with the fact that race is used to help people.
The Supreme Court has embraced a so-called colorblind interpretation of the law before, most notably with a decision that struck down affirmative action in college admissions. All of this comes as a major redistricting races play out across the country, with 2 states approving new maps and a dozen others considering redrawing theirs. Joining us now is President of the NAACP, Derrick Johnson. Derrick, thank you so much for taking the time to join Stay Tuned Now tonight. We really appreciate it. Look, the NAACP Legal Defense Fund argued today's case. How do you think it went?
Well, let me commend Janae Nelson and LDF for an outstanding job. She made plain that in this country, the problem isn't race. In this country, discrimination against race is the problem. She did an excellent job, but unfortunately, it appears that there is a likelihood that Section 2 of the Voting Rights Act will be weakened, and that will be an unfortunate outcome of this case.
I want to play a little more sound from today's arguments, and then you and I will talk again right after. Let's listen.
And if we look at many of the black Congress people who were elected, they came out of Section 2 opportunity districts. They don't have to be majority-minority districts. Many of them are crossover districts. And so if we remove Section 2, we also recognize that there will likely be a resurgence of discrimination because Section 2 plays a deterrent effect.
First, can you just remind us what Section 2 of the Voting Rights Act actually is?
Well, the Voting Rights Act was adopted in 1965 as a result of congressional hearings and the evidence that individual states they use race to exclude opportunities for African Americans and other citizens to truly participate in electoral politics. Section 4 and 5 was the strongest part of the act. It was knocked out earlier in the last decade. And Section 2 is basically saying that if race was a predominant factor, then you cannot proceed with a policy where race is predominant factor. It's a protector. It is something to ensure that all Americans can fully engage in the process of exercising their franchise or electing candidates of their choice. It is a preventive measure. It is the thing to remedy problems. And somehow with this case, we're hearing the government saying that the remedy is the problem, which actually blows my mind.
So 2 years ago, the Supreme Court said Alabama had to add a second majority black congressional district, right? If they were to gut Section 2, would the court be overturning its own precedent that was issued just 2 years ago?
Well, that's something everyone is watching to see, that, you know, the Supreme Court operates off precedent. And we just witnessed this Supreme Court upheld a similar scenario in the state of Alabama. And the fact that they took this case after just establishing that the remedy for the state of Alabama from excluding African Americans from fully engaging and participating is the drawing of a second opportunity districts. Not that there's a guarantee that African Americans get elected, but that African Americans in the state of Alabama could elect a candidate of their choice. That's the same scenario that we're looking at here in Louisiana. And I hope the Supreme Court will be consistent in their decision to ensure the protection of Section 2 of the Voting Rights Act stays intact, and the citizens of Louisiana will have an opportunity to elect candidates of their choice.
If the court does decide that lawmakers can no longer consider race in drawing districts, how would it impact voters?
It will have a severe impact on our democracy and voters. We'll be looking at the second post-Reconstruction era, where this nation made a commitment through its Constitution that equal protection under the law should be afforded to all citizens, that the right to vote should not be suppressed, that the ability of individuals to elect candidates of their choice should be upheld, and that we can have a multiracial, true democracy. And unfortunately, many people are seeking to overturn that, and I hope the Supreme Court will rely on their precedent out of Alabama and continue to ensure that all citizens of this nation can fully engage in our democracy.
Derrick Johnson, president of the NAACP, thank you so much. We appreciate it.
Thank you.
We thank you for watching. And remember, stay updated on breaking news and top stories on the NBC News app or watch live on our YouTube channel.